A divorce decree, which in North Carolina is formally called a judgment of absolute divorce, is the court order that legally ends your marriage. Once the judge signs it, you are single, free to remarry, free to file taxes as an unmarried person, free to move forward. But here the decree usually does less than people expect. And one statute can permanently cost you property and alimony rights if you don't understand it before that decree is entered. In many states, the divorce judgment is a master document that resolves everything. North Carolina usually works differently. Here, the judgment of absolute divorce frequently addresses only the divorce itself, the legal end of the marriage. Custody, child support, alimony, and property division are typically handled in separate orders or in a separation agreement the two of you signed, which may or may not be incorporated into a court order. That is not a defect. It is how North Carolina practice is built. But it creates the single most important thing on this page, and it is the reason we made this video. Entry of the divorce judgment cuts off claims you have not preserved. If your claims for equitable distribution, which is property division, or for alimony are not asserted and pending when the absolute divorce is granted, they are lost. Permanently, courts cannot revive them because you didn't know the rule. So, if your spouse files for divorce and you have property or support claims, you have to get them on file before the judgment is entered. This is the number one reason to have a lawyer at least review your situation before a divorce goes final. Even in a case everybody is calling simple, child custody and child support are different. Those can be addressed after the divorce because they belong to the ongoing needs of your children. North Carolina is a no-fault state. To be entitled to an absolute divorce, you only need two things: 1 year of separation. You and your spouse must have lived separate and apart in different residences, not just different bedrooms, for at least one continuous year, with at least one of you intending the separation to be permanent. Resuming the marital relationship restarts the clock. And 6 months of residency. At least one spouse must have lived in North Carolina for the 6 months immediately before filing. Nobody has to prove cheating, abandonment, or fault of any kind, and one spouse cannot stop the divorce by refusing to participate. The path is usually straightforward, and there are 4 steps. You file the complaint. In North Carolina, it is a complaint, not a petition, and it goes in the county where you or your spouse lives. You serve your spouse by sheriff, by certified mail, or another approved method. Your spouse then has a limited window to respond. You resolve or preserve the other issues. This is where that trap lives. Property and alimony claims have to be settled by agreement or on file with the court before the judgment is entered. And then entry of judgment. Most uncontested absolute divorces are granted without drama, often on the paperwork or in a brief hearing, and the judge signs the judgment of absolute divorce. A short checklist right after the decree is entered saves real headaches later. Read the judgment carefully and confirm every detail is accurate, names, dates, and any terms it contains. Errors are easiest to fix immediately. Update your estate plan. Revise your will and any trusts and update your powers of attorney and healthcare directives. Change your beneficiaries on life insurance, retirement accounts, and payable on death accounts. Divorce does not automatically redirect every beneficiary designation. Check each one. Separate what's left of your finances. Close joint accounts and cards, retitle vehicles and property according to your agreement or orders, and update your tax withholding and your insurance. And your name. A spouse who wants to resume a former name can have that included in the divorce action or apply to the clerk of court afterward. Then update Social Security, your driver's license, and your passport in that order. Certified copies of the judgment of absolute divorce come from the clerk of Superior Court in the county where the divorce was granted. Bring the file number if you have it and a photo ID, and expect a small per-copy fee. One distinction worth knowing. North Carolina Vital Records handles divorce certificates, which are a different and much shorter document. For remarriage, immigration, or a name change, you will usually want the certified judgment from the clerk instead. A divorce decree and the court orders around it carry the full force of law. When an ex ignores a court order, skips support, refuses to sign over property, violates the custody schedule, the enforcement tool is contempt. That is the court's power to punish a knowing, willful violation of its own order. Penalties escalate from makeup performance, fines and attorney's fees all the way up to jail for stubborn, willful violators, and courts typically give the violator a chance to cure before dropping the hammer. Here is the critical distinction. Contempt only works for court orders. If your terms live in an unincorporated separation agreement, a private contract that was never made part of a court order, then enforcement is a breach of contract action instead. Which document controls your obligations changes your remedies. Know which one you have. The decree itself is usually the easy part. The rights that live or die around it are not. At McCrary PAC, we make sure families cross the finish line with nothing left on the table. Claims preserved, agreements enforceable, paperwork done right the first time, family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. If your divorce is approaching final judgment and nobody has checked your property and alimony rights, call us this week. After the decree, it is too late. The full guide is linked below.